before Jeff gets started on that, I want to talk about what that will can actually control, because it's a little counterintuitive, but the will doesn't necessarily control disposition of all of your assets at your death. So it's important before you fill this out to really understand what this will can and cannot do. So the main thing to be aware of is that assets with beneficiary designations, such as retirement accounts, life insurance policies, and pay on death accounts or transfer on death accounts, those you might be able to identify by a POD or TOD on your account statement. Those accounts are not, in life insurance policies and retirement plan benefits, those are not controlled by a will unless there's no beneficiary named or no living beneficiary named. So for instance, if you named a spouse who has since passed away as a sole beneficiary, that person is no longer alive, so it's the equivalent of having no beneficiary named. And in that case, those assets would pass pursuant to a will. But if you have a living beneficiary named, those assets will not be controlled by a will. So it's really important to know that that's the case when you're thinking about filling out this will. Similarly, joint tenancy accounts or real estate titled in joint tenancy or with right of survivorship, that could include, for instance, if the deed to your home says, Jane and John Doe, husband and wife with right of survivorship, that property would pass automatically to the survivor at the first death. And similarly, a joint tenancy account would pass automatically to the survivor at the first death. It would not pass subject to the will. So for example, if you have a retirement account where you name your brother as primary beneficiary, and maybe that dates back to before you had children, an old beneficiary designation, maybe from your first job, and you fill out this will today and you say you want to leave everything to your children, the will does not override that beneficiary designation, so that retirement account is still going to pass to your brother. So it's important to be aware of that before you're filling this out. And similarly, it's important as part of this process, in addition to filling out these documents we're going over today, to actually go through your finances, check title to all of your accounts, and be looking for joint tenancy, pay on death, POD, or transfer on death, TOD, or anything that says right of survivorship. Sometimes you'll see an abbreviation for joint tenancy with right of survivorship. That would be JTWORS. And if you see any of that, pay special attention to what's going to happen to that account if you pass away, and make sure you're comfortable with the result. Also, you should check the beneficiary designations on all of your retirement accounts and any life insurance, and also check to see what the title says on any of your real estate. So an easy way to check title to real estate, this isn't official, but it's a quick way that's more usually accurate, is to look at your property tax bill and see how it's made out. That might not always be accurate. The best way is to actually check the title, but that could be a quick way to double check. So with that said, anything that is not subject to beneficiary designation or joint tenancy or right of survivorship or some other pay on death designation, anything else in your name is going to be subject to the terms of this will that you fill out. And if you are an unmarried person, you have the power to control the disposition at your death of all the assets that you own, everything in your name. If you are married, it's important to note that the assets you can control disposition of at your death are all of your separate property and your 1/2 interest in community property, so long as that community property isn't held in joint tenancy or with right of survivorship, so that it passes another way. Note that unless with community property, you don't actually have a legal obligation to leave your half to your spouse, although many people choose to do that. There's no legal obligation unless you have a contractual obligation to do so, such as a premarital agreement. So just be aware that unless you have a contractual agreement like a prenup, you're not obligated to leave your half of community to your spouse. And I
Caitlin,
think
maybe it
that's
makes sense. Maybe it makes sense to give the audience a definition of community property and separate property.
a good point, Jeff. So separate property is anything that you bring to the marriage, so any asset that you owned prior to getting married. And as long as you kept that separate property segregated throughout the course of the marriage, meaning in a separate account that you never contributed community property to, all of the growth and the income on that asset is also separate property. And then anything that you receive during the marriage by gift or inheritance from a third party is also separate property. And similarly, if you keep it segregated properly in its own account, then the growth and returns on those investments are also separate property. Community property is defined in California as anything that's not separate property. So it's the catch-all. California heavily favors the community, so community property is the default. But the easy kind of practical way to think about community property is it's anything that you earn during the marriage through your efforts, through your labor. So your salary and your wages are community property and owned 50-50 by you and your spouse. And with all of that said, if you have a those are the default rules under the law. If you have a premarital agreement, then all of that can be altered. So those default rules might not apply to you if you have a premarital agreement in place or a postnuptial agreement in place. So hopefully that's helpful to keep those things in mind as you fill out the statutory will. And I'll pass it back to Jeff to walk you through it.
Hey, thanks. All right, so looking at the will here, and again, hopefully you can see that we're obviously going to walk through every portion of this will, but I want to direct you to the questions and the answers that are listed up front here about this will. They're actually relatively helpful, and I actually encourage all of you to look through it. And in case there are questions that you have, some of them may be in this section, and the answers, like I said, are pretty helpful. So I really encourage you to take a look at that at those documents. There is a couple of things I will note in here about that where the information is not correct. There is, if you look at question 8 there, it says, are there reasons why I should not use the statutory will? Part of this answer is correct, and we've already actually alluded to some of this. This is a simple will, and it says it's not designed to reduce death taxes or other taxes. Talk to a lawyer to do tax planning, especially if your assets will be worth more than $600,000 or the current amount excluded from the estate tax under federal law at your death. Personally, I'm not sure whether that $600,000 is referring to what is excluded from under federal law at your death, but if to just ensure that you're not confused about what is actually excluded from the estate tax, it is not $600,000. It is actually $11.58 million. It hasn't been $600,000 since I think about 1999, maybe, or 2000, or maybe 2000. I don't know. I don't know if you remember, Caitlin, but I don't remember. It was a long time ago. So the current amount excluded from the state tax is $11.58 million. So it's to the extent that just to avoid any confusion, I wanted to point that out there. Okay, but otherwise, most of this information is pretty helpful and pretty accurate. So I encourage you to look through all of these questions in case some of you may have questions about what you are filling out here that we are not addressing in this webinar. All right. All right. Scrolling down to the will itself, you see there on the top there, you just fill in your name in print. And before we talk about the actual substance of the will, I want to point out a few things. This will, first of all, is very rigid. Caitlin alluded to this up front, that these are statutory forms. They are, designed to sort of one size fits all, right? But the reality is that we all have different sizes, right? And so this will may not fit exactly with what you actually want to do with your estate upon your death. I am going to encourage you not to veer outside of the terms of this document. So if you have, you want to leave a bunch of different things to a bunch of different people, this will is not going to accommodate that. So you're going to have to uh, accommodate your desire and as from an estate planning perspective, you're going to have to accommodate those desires within the bounds of this document, and you'll see what I mean as we go through it. It's got some very limited options as to what you can do with your property. Okay. Uh, the other thing is, if you are married, that the, oftentimes this, and in particular if you are married with children, this document can be really easy to fill out if you are going to leave everything to the surviving spouse, and then in turn leave everything to your children upon if you happen to be the second spouse to die. This will can actually be really simple to fill out. If you are single, maybe it's a little bit more complicated, but in any event, you want to make sure that you are cognizant, if you are married, that, as Caitlin said, that you are considering this in terms of your half of the community property and all of your separate property, all right? Because it's not going to also control your spouse's half of the community property or their separate property, all right? Okay, so getting into this here, if it actually is easier if we scroll down to section 5 and then work back a little bit here. If you, from a simplicity standpoint, if you are going to leave everything, if you are married and going to leave everything to your surviving spouse, you will see here what you're going to do is actually sign these boxes that are off to the right here. And if you were leaving everything to your spouse, then you would just sign in choice 1 there, that box there off to the right. And then likewise, if you were going to choose choice 2, nothing to my spouse and all to my children or my descendants, right? You would sign in box 2 there, or choice B. And then choice 3 is and typically you're only going to choose choice 3 if you are single. You would leave everything to the following person. So that's everything to one person. Or choice 4, which is if you, and actually you want to write that person's name. There's a blank below there under choice C, and you want to write that person's name in there below and then sign off to the right. And then choice 4 allows you to leave your entire estate among multiple people, and it gives you 4 blanks down there below. So again, it really only allows you to pick 4 people, up to 4 people to leave your assets to. And it leaves everything equally. You cannot say I want to leave 10% to A, 15% to B, 25% to C, and 50% to D. It's going to be equal among all 4 people. But you would write their names in, and again, sign off to the right. So in any one of these, in this paragraph, you're only ever going to sign in one of those boxes, all right? And that's, again, if you were going to leave everything, house, cash, anything, again, that would be subject to this will in accordance with one of these choices. Now, going back up, if you wanted to leave specific gifts of cash, again, to specific people, you would write in the person below that who is to receive that, and then next to that, the amount, and then you would sign your name below that there, all right? And then above that, there is number 3, specific gifts of tangible property. So your household items, your automobiles, things, your personal effects, things in your household, your furniture, clothing, those kinds of things. If those are going to go to someone different than is listed in section 5, then you can write those things in there. You do not have to fill any of these paragraphs in. If you're going to fill in number 5 there, you want everything going to one specific person, you do not need to fill in sections 2, 3, or 4. You can skip down to 5 and you're done. These sections 2, 3, or 4, if you are only going to leave something to someone else other than the person that is listed or persons that are listed in section 5. All right. So again, section 3, again, you can choose to leave everything to your spouse. All of these subsections A, B, C, and D are the exact same. So it's all to my spouse, nothing to my spouse, and all to my children. Everything to a specific person, or divided equally among multiple people. And again, you would just pick the particular box of your choice. And then section 2 is your specific residence, your personal residence. If that was going to be, again, distributed differently than everything else, you, again, would choose all to my spouse, or just to my descendants, or to a specific person, or equally among the people of your choosing, right? And again, sign the applicable box there, all right? So conceivably, you could fill out every one of these sections, but for most people, that's probably not likely, is my guess. Most people, I think, are likely to fill out just section 5, all right? All right, section 6. If you have minor children, that is any child that is under the age of 18, then you will want to nominate guardians who can act on their behalf if you happen to pass away. The first thing, there are actually several things that you should probably consider in selecting this guardian. The first thing is that you should know is that this is just a nomination, all right? Ultimately, the person you name here still gets vetted and considered by a judge, and a judge ultimately makes the decision as to what is going to be, or whether this person is going to be acting, or it fits and is going to be in your child's best interest as their guardian. And now your nomination goes a long way toward making that determination, but it is still just a nomination, and ultimately a court makes that call. You can imagine a situation where you nominate somebody to act as your child's guardian right now, and 5 years later, that person that you have nominated, let's say, has a substance abuse problem, and you pass away. This issue is in front of a judge, and the judge now says, all right, let's check into the background of this person, and they find out that this person now has a substance abuse problem. That is probably not the best situation for your child to be in, but a judge needs to have the ability to vet that at that particular time, right? And so that's why your nomination is just that. They want to verify, a court wants to make sure that this is indeed the best choice for your child, all right? The other things that you should probably consider in making this, and Caitlin, you can chime in with other things that you advise your clients. But a lot of things I tend to consider are geography. I think courts tend to have a bias, and for good reason, toward keeping your kids in the place where you currently reside. And so to the extent that your guardian is nearby, that tends to be a much better situation for your kids. I think obviously the relationship that they have with this potential guardian is important. If there is zero relationship there, obviously you're probably not going to pick that person. But look, we all have limitations, and so you've got to work within the people around you to make the right choice here. I think that also applies to geography as well. A lot of us here in the Bay Area are transplants, and to the extent that you don't have any family, and maybe here in the Bay Area, or that you don't have friends that you trust to fill that role here in the Bay Area, maybe you are stuck picking someone who lives quite a distance away. And I think, and sometimes if that means picking someone who lives in a different state, it raises another issue, which is that California has an interest in not just letting your child leave this state without a guardian already in place if you happen to pass away. If your nominated guardian were to fly here, pick up your child, and take them back to their state, as a technical matter, that could be considered kidnapping. So, and you, to the extent that you can avoid that, you probably would like to. So, ideally, you would probably want to name a temporary guardian, nominate a temporary guardian in California to help effectuate a legal transfer of that guardianship from California to whatever state that you would want your permanent guardian to be in, whether if that's in Nevada or Ohio or wherever that happens to be. Again, in the context of this will, that's very difficult to do. It is the one place where I would maybe recommend actually writing something additional in, if anywhere. All right. So going through these boxes, when you name your first choice for guardian of the person, my preference is to name the spouse as that person, even though the instructions say, if at my death I have a child under 18, whether that child is alive at the time this will is executed or born after the date this will is executed, and the child does not have a living parent, I nominate the individual below as guardian of the person of that child. I still like to name the parent just so that there's no confusion about who should actually be doing this. If I don't want a court coming back to say, well, is there something wrong with this parent? Maybe you were separated, maybe you weren't fully divorced, and maybe there's an issue there that someone else, another family member, might raise about this parent. You want to make sure. For me, it's just additional clarity. There are three choices here: first, second, and third. And for me, I think it's a good idea to name the other parent as the primary, as the first choice here. I think there are different schools of thought about that, but that's my preference. And if you're going to pick, and in your second choice, say a family member that lives in another state, then what you would probably do, at least this is what I would do, is I would list a temporary guardian here in California in the second choice, and next to their name, after I write it in, I would write in parentheses temporary, and maybe put California or something next to that. And then in the third choice, I would name the permanent guardian, and in parentheses put permanent, and then identify the state in which that person lives, or country for that matter, right? That's how I would go about doing that if my only choice here was someone out of state. If they are in state, not a problem. Just list them in that order that you want them to serve. Okay? All right. Section 7. This is a place where you can choose to have someone hold, if you were to pass away, you can pick someone to hold assets for the benefit of your child if that child happens to be under the age of 25. And it's and that's for obvious reasons, right? Obviously, if your child is still a minor, they're not going to be old enough to actually own these assets. But even after they turn 18 and they actually are of legal age, there may be good reasons to have someone else look out for this money or these assets until they reach a certain age, all right? And the statute that this provision allows you to do this under limits that age to 25. And so if you were going to name a custodian, again, you can name first, second, and third choice. And then down there at the bottom, there is another box at which age that you would like that custodial relationship to end. And you can pick anywhere from 18 to 25, as the instructions there indicate. All right. Again, if you are married or the other parent is around, you probably want to name that parent as the first choice as the custodian here as well. And then again, name second and third choice custodians thereafter. All right. All right. And then below that is where you list your executor. Again, you may, if you are married, you probably want to list your spouse there, and then second and third choices below that. And then Section 9 refers to a bond requirement. We talked about a little bit about this in the power of attorney, but just to reiterate the issue, this bond is something that typically has to get posted in a probate proceeding, and it again is to protect the estate in case the executor gets into that position as the executor is appointed by the court and then runs off with all of the assets. That bond is there to protect all the beneficiaries in case that were to occur. Again, if you're picking someone that you trust to fill that role, by and large, the bond is a waste of money, but you can make that decision as to whether or not you're comfortable with waiving that bond. If you do decide to waive that bond, you will sign in that box there under paragraph 9. Okay? All right. Now, below that, this is where you sign. And as you're probably well aware, wills have to be witnessed. They do not have to be notarized. In fact, there is no place in this document for a notarization block. So they do have to be witnessed. They have to be 2 adult witnesses. They need to be persons who are not related to you, who are not named in this will. And so typically, my recommendation, at least in your position, is probably that a colleague, coworkers, maybe even neighbors make good witnesses, unless you were leaving something obviously to that neighbor or having that neighbor or colleague serve in one of these capacities named in this will. You would make sure that they actually watch you sign this will. And as a practical matter, I think there are some difficulties in making that happen. I know that we've gotten a little bit creative in our office to try to make these things happen. I know Caitlin has actually signed something on the hood of her car before, but there is, if you want to put out a table between you and your neighbors' houses or something like that, set the documents down, make sure that they bring their own pen with them, and make sure they're standing out on their front porch, and you walk over there, sign your will in front of them, and then you want to declare to them, this is my will, I am signing it, and I would like you to be my witnesses to that signature. You sign your name, you can then step away, they can walk over, sign their name. Down below there, they need to date, sign, print their name, and put their address then below that, right? And your will is now complete, all right?
Yeah, and just to be clear, that when we're talking about being creative about signing, we're just talking about, we're recording this during the quarantine when it's right. Been very difficult for clients to sign. So I don't know how long this recording is going to be out there. So if you're hearing this, this is April 2020 that we're recording this. So if this is in the future that you're hearing this, it's not normally such a challenge. We don't always set up tables in between houses and sign documents on the hoods of our car, but currently we do. So.
Thank you, Caitlin.
It's the world we're living in today. Right. And the one other thing I just wanted to mention is that a common question I get from clients is asking if they need to get permission from people before they name them as their executor or guardian or power of attorney or healthcare agent. And there's no legal requirement that you do that. I think, it's a personal decision. Practically, it can make sense. It might give you peace of mind to know that the people that you named are willing to act. But on the other hand, you don't have to talk to them about this or even tell them that you named them. If you've designated a few choices, if the first person isn't willing to act when the time comes, it will just fall to the backup person. And I think what I would just caution people about, especially with the guardian provisions, that can be such a sensitive subject in families. And if you're choosing, for example, one sibling and not your other sibling, and you announce that to the family, that could create problems for you that are you just might not want to deal with. And hopefully, those provisions aren't necessary, and you live, well beyond your children reaching the age of majority, and you might have stirred up trouble for no reason. So I just want to caution people that sometimes, people typically, I think, in my experience, when people are asked if they're willing to serve, they are. I think most people are honored to be chosen and to be asked. And similarly, if people aren't chosen and aren't asked, they can be offended. So just be careful about that when you're talking to people about your documents. Probably
Yeah,
less.
and I think. All right, go ahead.
No, that was it. That was all I wanted to
I was
say.
just going to say that I think it also that speaks to the point of that it actually, as a practical matter, while you don't have to tell these people, it actually is a good idea to probably talk to them about this if you have time,
Yeah.
because I think giving everybody the heads up that these things are out there, that they could be fulfilling these roles, um, uh, that it makes everybody feel a little bit better about it. And I think, in my experience, the worst situations have come about where people are surprised about what's at that time, and so letting people know around you, particularly those people who might be filling those roles, is a good thing if you can, right? Um,
You just might have to swear into secrecy.
that's right. That's right. All right, so a few things. Now that we've gone through all the documents, I wanted to mention a few things about, in particular, storing your documents. Now that you've executed all of these documents fully, you've gotten them notarized, you've gotten them witnessed, and all of that. Uh, what do we do with all of them? The originals, the laws, is particularly in our area of the law is actually a real dinosaur. And so these wet signatures really still do mean something. In particular, the will. Uh, that will, there is actually a statute on the books that requires that this will, upon your death, be lodged with the court in the county in which you actually resided at the time of your death. And so and it has to be the original, or and if it's not available, you can lodge a copy, but there are additional steps and hoops you've got to jump through to prove that that copy is a true and correct copy of the will that was actually signed. And so, to the extent that you can avoid that and you can keep an original in place, it's really important. And while you're doing that, and you may as well keep the originals of both your power of attorney and your healthcare directive as well. So how do we go about doing that? Um, there are a couple of different ways. My personal feeling is that keeping it in your house is the best way to do that, even if there is a chance that your house might burn down or that it might get burglarized or those kinds of things. Um, if it, For me, it's more important that the people who might actually be filling these roles, if you were incapacitated or when you pass away, it's more important to me that they be able to access these documents easily and quickly. And so keeping them in your house, as a practical matter, feels like it makes more sense to me. Now, the alternative to that, which you'll hear a lot, is put these documents in your safe deposit box if you have one at your local bank. Um, Obviously, that's safe, right? And there's very little chance it would get stolen. There's very little chance that, I mean, even if it got burned, it's in a vault, and it's probably going to be protected, right? So it's very little. There's very little chance of it getting destroyed or whatever. It's likely to be there when you pass away. So from that perspective, it makes a lot of sense. But getting access to those documents can prove to be a little bit more difficult. There is a statute on the books that allows someone to get access to a safe deposit box for the sole purpose of extracting a will or estate planning documents. But even with that statute on the books, as a practical matter, getting through the bank and actually getting to that box itself can still prove to be a bit more of a hassle than you'd probably like it to be under those circumstances. So if you feel more comfortable doing it that way, it's not the end of the world to me, but and certainly a safe way to do it. My preference is to hold things in your house and let the people again know who are filling these roles. Let them know where you are keeping these documents so that they can get access to it. If you've got a fireproof box and those kinds of things, and if they know how to have the key or if they have the combination to it, that's probably a good way to go about that thing from my perspective. I don't know, Caitlin, do you have different thoughts about that?
Um, I don't. I think I agree with what you said. I think, I think if it's at home, just try to find the safest place possible. If you have a fireproof safe, I think that's a great idea, or a fireproof file cabinet. It's a great idea. I think, yeah, at the end of the day, though, you need to make sure someone's going to have that when you're gone, or if you become incapacitated. That's the important thing. So at least, letting, a family member or the persons you've named, in these rules, letting them know how to access the documents. That's the important thing.
All right. Um, a few final things, or a couple of just final things. I wanted to mention that if you've now gone through this webinar and you still have questions about filling out these documents, you are welcome to contact a clinic that we are also sponsoring or putting on, and we are happy to help you with those questions that you may have about filling out those documents if we haven't answered those questions on this webinar. So feel free to reach out to us if you want to do that. And I think lastly, I know Caitlin said thank you. I also want to thank you myself for your tireless efforts and all the hard work that you've put in to keep us healthy in this community and taking care of us on the front lines and putting your lives at risk to do so. It's we can't thank you enough. So, do you have any final thoughts, Caitlin?
No, well said. Yeah, thank you. Thank you,
All right.
everyone.
All right. Take care, everybody. Thank you so much, and we'll look forward to perhaps hearing from you. Bye bye.
Bye.